Okay, well, I appreciate you making the time this morning. And if you read the description of this, hopefully you had time to walk your dog, feed your cat, have a cup of coffee or tea, and settle in for this talk. It's always good to start the day with something new that we could learn. So I'm going to start with just presenting Nerisha before she presents to us. And she doesn't know that I'm going to share a little bit of who she is and her bio. But really happy to have you, Nerisha. So Nerisha Soodeehul is a California admitted attorney since June of 2007. She has 6 years of legal experience in South Africa, which you'll notice her background is South Africa. Since her California admission, her practice has focused on estate planning, trust administration, and probate matters. Nerisha has prepared estate planning portfolios for single and married persons, assisted clients in trust administration matters at first and second death. Her probate law experience ranges from simple probates to very complex and ongoing probates. Nerisha's experience has afforded her the opportunity to meet a wide range of people and assist them in creating a customized estate plan. I speak from experience getting to know Nerisha a little bit throughout this last year, that she is very skilled in kindness. She is a great listener, great communicator, and really effectively and easily communicates estate planning in a really understandable way if that's something that is necessary for you. She is a new treasured member of our Cancer Support Community Legal Advisory Council. We have about 12 members, Nerisha is one of them. And she's already given so much time to CSC through presentations, through writing newsletters, and she also wants to help volunteer in stuffing and addressing envelopes for us. So Nerisha, a big thank you and welcome to you. Mary, hi, good to see you. Carlotta, good to see you again.
Well, first of all, thank you, Libby, for this opportunity. It's always good to chat with you and to participate in various community activities. So thank you. Thank you. And as Libby said, I am an estate planning attorney. My areas of practice are estate planning, trust administration work, and then probates. I call myself a reformed litigator. I did litigation work when I worked up in Sacramento for 6 years. And then we moved from Sacramento and we now live in Danville. And for the 8 years that I'm here in Danville, I have my own practice. And so it is me, myself, and I, and the dog on a good day. And so we're here on, I would say a sunny day, but it's cool and we're blessed for the coolness. And so any questions that you'd like to ask off the bat? Anything that...
Nerisha, I have a question for you. Just Zoom etiquette and what you prefer. If people have questions, do you want them to chat them in the box or verbalize them at any time?
If we're a small enough group that you could simply, raise your hand and let me know, and I'd be happy to take the question, or you'd keep an eye on if I don't miss anybody, Libby. So I'm happy with that.
Okay. And if you joined us yesterday with Yvette, her style was she presented something and you asked questions. Nerisha would like this to be a discussion, open to questions and conversation if you have any things specifically to you and your planning or broadly speaking.
Anything to start us off, ladies? No? Well, let me tell you a little bit about us, a little bit about estate planning and how I think of it and what it's there for in my mind. As Libby said, I've been in practice now for 14 years, and I practiced for 6 years in South Africa. So I'm a 20-year attorney. And during the course of my career, what I've come to realize is that people need to have comfort and care in their decisions, whichever those decisions may be. So whether it is when I did family law, when I was working as a criminal defense attorney, I did labor and employment law. But in this space, the question of passing away is such a sensitive topic and brings up so much of emotions in very many different ways that being kind and gentle and supportive is, for me, the best way to do estate planning. So I spend a lot of time talking, listening, giving advice, giving gentle and sometimes not so gentle nudges in particular directions. And then way back when I worked as a public defender in South Africa, I met one of the most senior senior attorneys. He was one of the attorneys who was on the Nelson Mandela treason trials. If you know a little bit of South African history, and his advice to me as a I think when I met him, I was still a law student, was if you listen to your clients, the clients will give you the answer. It's then your job as the attorney to craft that answer into a legal analysis or a legal answer. So here, this is a safe space. So if you have any questions, feel free to interrupt me at any time. So the kinds of trusts or the kinds of estate plans that I prepare are focused into two areas. They are there primarily to avoid probate. And the question always is, what is probate in California? And so probate is nothing more than the court process by which we administer someone's estate. And that's quite a complex sentence. If we break it down and start with simple terms, what is an estate, right? Because you talk about estate planning and the question is, well, what is an estate? So an estate is nothing more than the things that you own for a particular purpose. Or if you think of it this way, we put certain assets into an estate and we categorize them as an estate for different purposes. So if you think of it this way, we have those assets that generate income, right? So your bank account, you get interest on it. If you have investment accounts, you get dividends and the like. Salary is income, and we pay income taxes on that. And so those are assets that would be in the income tax estate, right? So we categorize certain assets for certain purposes. So when we talk about probate, we look at what assets would be under the umbrella of a probate estate, or what assets fall within the probate estate bucket. And those would be your house, which is the biggest asset that we talk about, as well as bank accounts. So think of checking accounts, savings accounts. I noticed you're making notes, Mary, Barbara too. I saw. If I'm going too fast, just stop me. So it's bank accounts, checking accounts, savings accounts, CDs, and things like your brokerage accounts. It's your furniture, your furnishings, it's collections that you may get. So if you've collected dolls, which one client of mine did, she had those beautiful, beautiful porcelain Dresden dolls, and they were amazing, right? I had another client whose family came from Germany, and he collected beer steins. And so people have interesting collections, right? I've learned a whole bunch from those. So those kinds of things are what we would call probate assets. And the name of the game is, how do we avoid probate, and why would we want to avoid probate, right? So at the outset, probate is just a means of controlling the process. So it's the court process And as a result, as soon as you're in court, you are faced with a variety of legislations, rules, regulations, timelines, and you are at the mercy of the court system. So we want to avoid the probate process because it is time consuming, it's expensive, and also everything that you file at court is open to the public. And so when I was a newly minted attorney at my first job, my supervising attorney said to me, I need to go and kind of learn what the courts look like and get to know the clerks. And so off I went. And truly, I wouldn't believe it if I hadn't stood in line. And the gentleman in front of me, he was like, hey, Jane, how are you? And he was like, can I get the court filings from yesterday? And I'm like, why would he just want? And she had them ready. It was a stack of files. And basically, that's what his job was. His job was to read every piece of paper that was filed in court the day before, right? And so because everything that gets filed at court is public, anybody can go up to the court and get a copy of anything. And what his job was is he was looking for people who had real estate, and he would then speak to the real estate realtors in the neighborhood, and they would send letters to surviving spouses or attorneys to say, if you want to sell, they could assist you. So there is that privacy piece of it. The second piece of it is timing. An average probate takes, generally speaking, 12 to 18 months to complete, right? And so it's a long time. However, we're in and hopefully towards the end of a pandemic. During the lockdown period, courts were closed. The probate department specifically wasn't considered an emergency department in the same way the criminal department and the family law department was. So a lot of the probate cases were put on the back burner, and the probate court is particularly backlogged. So probate cases are now taking anywhere between 18 to 24 months, if not longer, to complete. So I filed paperwork in a probate matter in Alameda County. It would be called the petition for final distribution, meaning that we had finished the process and we just need the court order to distribute the assets to our beneficiaries. I filed it in June. My hearing date is March of next year. That's 9 months to get a hearing date to finalize the estate, which means that during that 9-month window, nothing happens. All the money that we have is frozen, right? We can't access it. We can't distribute it. Nobody benefits during this period, right? So it's time consuming. But the other piece of it, and the bigger piece of it, is the cost of probate. And so, any questions while I take a breath? Am I giving you good information? Anything, ladies?
You know, it's just making me think of just giving a glimpse into cancer support community when people leave us in their planning. And when a spouse passes away, I talk to the spouse who is dealing with the probate, and it's very difficult for them because it is so long. And, you know, they go through all these emotions of anger and then disappointment and just like, oh, I just can't wait to get over all of this. It's really difficult.
Frustration, right?
And yeah, so as you're talking, it's reminding me of the other side of things.
Right. And before I circle back to that, let me get to that last point of cost. Why do we say that probate is so expensive, right? So probate fees is set up in such a way that you would pay me as an attorney for the estate a certain fee, attorney's fees, you would pay the executor, the person that is actually appointed in a will, probate fees as well. And then there are certain court costs that are payable as well. So court costs would be the court filing fees, the newspaper publication costs, those generally accepted expenses the court will allow to be reimbursed or are payable during the process. Now, here's what's important to look at. How do we calculate probate fees? How do we calculate attorney fees? So remember, these are lawyers, right? So lawyers drafted this and they do not believe in simplicity. So this is how it works. Stop me if you get lost. Probate fees is based on the value of the assets under administration at date of death. And what we look at for probate fees is the fair market value at date of death, right? So when we calculate probate fees, we are not looking at what we call the net value of assets. We're looking at what we call the gross value of assets. So if we take a house in and around this area, right, because that's the biggest asset that would go through probate is your house, the greatest value. The average house value here, let's say, is $1 million. Even if this is a new purchase and you haven't paid the mortgage company a penny on it, the mortgage is still $1 million, but the house value is $1 million. So when we calculate probate fees, what we are looking for is the fair market value at date of death, which is the million. And the complexity comes in how we calculate fees. So it works on a sliding scale and it's based on value. So the probate code, which is the legislation, tells us that it's 4% of the first $100,000 in value. So it's at $4,000. It's 3% of the next 100,000 in value, which is 3,000. Now, if the value of the house is 200,000, I'd take the 4,000 and the 3,000 and I'd get 7,000. Now we know that you can't buy one bedroom for $200,000. So we have to go to the next number, and that's 2% of the next 800,000 in value, which is 16,000. So if you use my handy dandy example that a house is worth $1 million, you would pay probate fees to me as the attorney of $23,000. You could potentially pay another $23,000 to the executor, and then we would pay court costs on average of about $1,000 to $2,000. So what the estate, meaning the assets that are under administration, would pay to an attorney would be $23,000 on $1 million value, another $23,000 to the executor on $1 million value, and then court costs of $1,000 to $2,000. So a really, really high estimate would be about $48,000 using my example. That's a lot of money, right? Libby and I were talking, and my son is 17, and he's in his senior year. College is around the corner. So let's assume that you would pay me $23,000. That would be a year's worth of college, hopefully, right, for him. So if you think of it in that perspective, you could buy a whole new car for $23,000, right? So what we're looking at in the estate planning process is, how do we avoid probate? And the way that we avoid probate is to create a trust. So those are the reasons why when I do an estate plan, I look at what are the assets that you own. If you own your own home, then we're looking to create a trust. and we're looking to move assets that would go through probate from the probate estate bucket to the trust estate bucket. And so the process, the means by which we do that is, if you have your own estate plans in place, your attorneys would have told you to change title. And what does that mean? Like, how do you do that? What you would do is, for the house, the attorney generally would prepare a new deed for you. And what we're doing is we're changing ownership from you as an individual to you as trustee of the trust. So if we use Mary as an example, Mary would own her house as Mary Smith right now, right? If we create a trust for Mary, the trust ownership would be Mary Smith as trustee of the Smith Family Trust. So my trust is Nerisha Soodeehul and Prakash Soodeehul, that's my husband, as trustees of the Soodeehul Family Trust. And that's how we change title. Title is ownership. That's how we change ownership from you as an individual, or you and your husband, or you and your partner, you and your spouse, to, and the two of you, an individual, as trustees of the trust. Because the trust only works to avoid probate if the asset is in the trust. So we don't want delinquent assets or hanging around outside of the trust bucket that should be within the trust bucket. Any questions? Any comments? So if I circle, Libby?
Oh, I was going to say, I think Barbara's talking, but you're on mute, Barbara. Let me see if I can unmute you.
No, I said your IRAs can't go in a trust, can they?
So that's the next piece that I was going to talk about. So we've talked about what assets go through probate, and in order to avoid probate, we would move those assets that go through probate into your trust. But there are certain assets that cannot be owned, right, as trustees of the trust. And those are, as Barbara correctly points out, retirement accounts and life insurance. So under the umbrella of retirement accounts, a 401k, IRAs of any variety. So that would be a traditional IRA, a SEP IRA, which if you were self-employed would be a SEP IRA. A Roth IRA is very, very popular right now. Annuities, certain annuities, right? And then life insurance. Now, these kinds of assets are actually contracts. If you think of it this way, it's a contract between you and Vanguard, between you and Fidelity, between you and New York Life, for example. You pay the company a certain number of dollars over a certain period of time. Something happens. Either you reach minimum distribution age, or you decide that you would like to take your distributions at a particular age. And the company then, in terms of the contract, would pay you a certain number of dollars back, right? Alternatively, if you pass away, the value of either the life insurance or the value of the remaining assets in a retirement account gets paid to beneficiaries, right? And so the takeaway from today's discussion is two things. If you have an existing trust, check, double check, and triple check that all of the assets that should be within the trust bucket are indeed within the trust bucket. How do you do that? Well, if you look at your deed, it will say Mary Smith as trustee of the Mary Smith Trust. Alternatively, when you get your next property tax statement, in the top left-hand corner, it should describe you as trustee, or it should give a description as trustee, right? So check. On bank accounts, when you get your next statement, or if you get online statements only, which a lot of us have switched to, be sure to open up a statement the next time. And again, in the left-hand corner, you will see Nerisha Soodeehul, trustee. Alternatively, they abbreviate trustee in a variety of ways. And so it'll be TEE or TTEE, whichever way they configure it. Full word trustee, TEE, TTEE. That's how you know an account is in the trust bucket, right? So for those assets that should be in the trust, check and double check that you own it as trustee of the trust. On the beneficiary designation side of things, a 401k, an IRA of any variety, and life insurance, go in and make sure that your beneficiary designations are up to date, right? So if you're a married couple, generally your primary beneficiary is your spouse. Make sure that you have included contingent beneficiaries as well. And this is where folks fall short, right? They may list a primary beneficiary, but they forget to list a contingent beneficiary, right? Where do I see issues is the first spouse has passed away, right? And the surviving spouse rolls that asset over into a rollover IRA, for example. And when they've made that transition, that rollover, for example, they forget to nominate beneficiaries, right? Alternatively, the spouse is named as a beneficiary. Ladies, if you just excuse me for 1 second, the sun has come in and I just need to close the blinds because I'm quite literally blinding myself. Give me one moment.
Yes, you're very bright.
Yes. So what I was saying was that we have a surviving spouse who receives a benefit under a retirement account, and then they forget themselves to nominate new contingent beneficiaries. And so you want to go in and make sure that your contingent beneficiaries and your primary beneficiaries are up to date, right? Any questions? I hope I'm not boring you guys to tears. There we go.
I just want to say, I think you're making a very clear presentation of some very complicated information. So thank you. And
Okay,
so far, I don't have any questions.
I saw you looking around for a document.
I was pulling up my recent
property tax.
The property tax bill and looking at another asset I have that I happen to have in the drawer right next to where I'm sitting. And I checked them and they're fine.
Yes, that's a good thing, right?
Yeah, thank you.
And that's the funny thing is that once you've done your estate plan, it's like, okay, it's done, and you kind of forget about it, right? I was telling Libby that the busiest time of the year for me is now, like October, November, December, because my existing clients are like, oh, we've got to get our paperwork signed before the end of the year, right? And then new clients come on board because they're like, yeah, we should get that done before the end of the year. So there's a hurry and flurry of activity. But the thing to remember always is the trust only works if the assets are in the name of the trust. And so part of what your homework is as good clients is to undertake that process of getting assets into the trust. The second piece of it is what we call making sure that your schedule of assets are up to date. Now, the word schedule is one of the very few words that I cannot say American. My tongue will just not twist. It just is. That and tomato. Tomato, it doesn't roll off easily.
There's no right or wrong way to say it.
So,
right?
Yeah, I knew that I'd influenced my child when he said tomato, you know, with an American accent, which is always very funny for me. But we have what's called a schedule of assets. And your attorney should have prepared for you at the time that you signed your documents a schedule of assets. And what is a schedule of assets? A schedule is an inventory of the assets the trust owns at the time that you signed it, right? So, but things change all the time. You may buy a house, buy a second house, right? More likely open accounts, close accounts, right? And so what you should do is update your schedule of assets. Now, the way that I look at it is this way. You get a trust document. It's a good 30 to 40 odd pages long. If you think of it this way, anything up to the notary page belongs to me as the attorney. And why do I say that? I say that because you need me as an attorney, any attorney, to help you to do a formal written amendment if you want to change what I call the substance of the document, right? If you want to change the distribution provisions, the provisions that say who gets what, right? Alternatively, if you want to change the successor trustee provisions, and those tend to be the big changes that I see with clients, right? Then you need an attorney to assist you to do a formal amendment. Please, 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 please do not ever, ever, ever write on the original documents. You could invalidate the whole document. Don't put a line through documents and scribble in something, right? It can invalidate the entire document. When I give documents to clients, I put the originals in an envelope and I will say Mary Smith's estate plan, and in red, I have a full sentence. Please do not write on the originals. So that's my public service announcement for today. But the next piece of it, those schedules of assets, they belong to you as the client because you can create a new inventory without the assistance of an attorney. And how would you do that? You would simply follow the schedules in the same way that the attorneys has prepared them. And so you'd follow the headings and you would rewrite what the current or existing assets are, right? Sign and date it, put the new schedule in with your documents, and that's it. Schedules of assets does not have to be notarized. All we need is for you to sign and date it. The reason why you have a schedule of assets is twofold. First, the schedule of assets is the starting point for people coming after you. So your successor trustee or a surviving spouse, they're going to say, oh my, what do I do? What am I working with? And we flip to the back of the document, and that's our starting point, right? We look at what assets does the trust own, and then we can figure out what documentation needs to be prepared in order to get them under the umbrella of the new successor trustee, right? But the second piece of, it's the starting point for folks coming after you is sometimes things go wrong, right? So if we use Mary as an example, Mary was looking to make sure that an account, for example, was in the name of the trust, right? And because I was talking, that was in her mind. But what if she looked at the paperwork and it was not in the trust, right? And something happens and Mary forgets to put that account into the trust. Now I have an asset that's hanging around outside of trust, right? And what do I, as an attorney, do with this, what I call a delinquent asset, right? It's not under the trust umbrella. What I have to do is I have to go to court and I have to say to the court, and I have to use your will to say to the court, look, court, this asset belongs to the trust. How do I know it belongs to the trust? Because it's listed on that schedule of assets, right? Something went wrong and folks forgot to put it in the name of the trust. So help me, court, to pour that asset over into the trust. And so that's why you need a schedule of assets. It's a handy dandy tool for us to go to court and say, this asset belongs to the trust if you forget to put it into the name of the trust, right? And then again, just to repeat, the second piece is the starting point for people coming after you. So what I suggest to clients is when you do your tax return, January, February, March timeframe of each year, go to your drawer or your filing cabinet, or if you are an online person, check your accounts when you prepare your taxes, because that's when you're thinking about financial matters. Pull out your trust, look at the schedule of assets, and see if it's up to date, right? And if it isn't up to date, all you have to do is you could either handwrite a new schedule, type up a new schedule, you could do a spreadsheet if you're a spreadsheet type of person, whatever works, right? But update your schedule of assets because it's invaluable for folks coming after you. Now, personally, in my practice, I ask clients not to give me the full account numbers, right? Because it's a security risk for both of us, for you and for me. So I ask clients to give me the last 4 digits of an account as an identifying feature. But what I also tell clients is you can go home once you've signed the paperwork and you can create your own schedule, which has much more information than what I have, right? And this is where you can make the schedule as robust as you want to. So what a lot of clients do is they would put in full account numbers. They would give addresses of institutions. If they have a personal banker at Bank of America, that give the name of that person, a telephone number. And then you could, if you're the kind of person who's obsessive compulsive, yours truly, you would then create other kinds of schedules, right? And so you could create a schedule that has a list of all of your creditors. So it'd be things like credit card companies. Where do you have a credit card company? The account number, again, a contact information if you have any. Your mortgage details, right? Your mortgage details. Then you'd have a schedule of assets, a schedule that is specifically allocated for retirement accounts, right? So you just listed retirement accounts and other things like utilities, PG&E, we are Danville, so we are East Bay Mud. You know, when I lived up in Sacramento, it was SMUD, Sacramento Municipal Utility District, right? Whatever your utilities may be. So you can make this as robust as you like. Any questions? No? So I think I have about 15 minutes left.
Looks
and
like Vicky has a question, Nerisha.
Oh, Vicky, sorry.
That's okay. I'm wondering if it's possible to, even if you have a lot of assets, is it possible to completely avoid probate by setting up an estate plan with trusts and so forth?
So if you do exactly what I've said, or exactly as your attorneys have said, right, is creating a trust and making sure that those assets that should be in the trust are in the trust, and those assets that should have beneficiary designations have beneficiary designations, then you would be absolutely successful in avoiding probate, yes. So if you set up a trust and you have the assets in the trust, so the house, the checking and savings accounts, the brokerage accounts, right, then you have avoided the probate process. Does that answer your question?
Yes, it does. And just as a second question to that, how does say a house or a second home being in a trust, how does that affect selling that asset? Is there some hoops that you have to jump through in order to like get it? I thought you had to like get it back in your name as an individual and then sell it and so forth.
So two parts of that as an answer. While you are alive, and when I say you, I mean you as an individual, and if you're married, or then it's you as a couple, right? So while you are alive, the trust is what we call a revocable trust, meaning that you can make changes to the document. That's what revocable means. Sometimes the trust is also referred to as a living trust. And what that means is you've set up the trust during your lifetime, as opposed to a trust that is set up, come into existence after you have passed away. So the trusts are called revocable trusts or living trusts as a description, right? If while you are alive, the trust is revocable, then you are the trustee of the trust and you can do with it as you wish. So you are fully authorized to buy and sell assets, and you don't need the consent of anyone else other than your spouse, right? So while you are alive, you can sell without problem. That being said, mortgage companies have their own little idiosyncrasies. So a mortgage company, say for instance, you are refinancing, a mortgage company will often tell you, you've got to take the asset out of trust, get the mortgage in your personal name, and what you need to do is you've got to remember to get it back into the trust. And that's the second piece that you as clients have to be super, super duper careful about, right? Because if you tell the title company, look, I have a trust, can you please help me to get it back into the trust? They may tell you, sure, no problem, and then forget to do it. So I circle back to what I said to you before. When you do your tax return the next time, look at the deed or look at the property tax statement. And if you don't see that trust description, then you know that something went wrong. And then you go ahead and speak to your attorney, and your attorney can help you to fix that piece of it, right? So while you are alive, you should be able to have no issues with selling. Once somebody has passed away, right? And either if you're a single person at that first death, or if you're a couple at the first death, we do have to file with the county recorder's office what's called an affidavit of death. And so what that affidavit of death is, it's the deed by which we are taking the name of the deceased person off title. So in my case, Nerisha is me, Prakash is my husband, right? If I pass away first, the affidavit of death is going to say, County Recorder's Office, Nerisha and Prakash signed a deed on this date and both their names are on it. Nerisha has passed away. Here's her death certificate. Prakash, my husband, is now the sole owner. So to answer your question, Vicky, if there is a death, we have to record this affidavit of death first, and then the next person can sell. So there is a little bit of paperwork to be had in where there has been a passing and when we're looking to sell. Does that answer your question?
Yes, and so if there's only one person on the deed, then that's, you don't have to worry about that. And
While you are alive. And then if you are only a single person and a single person trust, your successor trustees will then record that affidavit of death to say, Vicky has passed away. I, Jane, am the successor trustee. And as a result, I, Jane, am now the owner of that property on behalf of the trust.
okay, great. Yes, thank you.
Any other questions? So I do want to go, I have about 10 minutes left. And so the other two big pieces of, or that are part of an estate plan are what documents should you have in place in the event that you lack capacity. So you are alive, but you lack capacity. You cannot take care of your own finances. You cannot take care of your own person, your own body, or a combination of the two of them. And those two documents are split up into, the general topic is called your powers of attorney. And generally we split them up between powers of attorney for finances and a power of attorney for health, right? In California, the power of attorney for health is called an advanced healthcare directive, right? So the power of attorney for health in California is called an advanced healthcare directive or a healthcare directive. Other states sometimes refer to this as a living will, right? Or a DNR. And that living will component and the DNR components are all encompassed under the umbrella of your healthcare directive in California. So what we're looking at for a healthcare directive is, largely speaking, who do you nominate in order to make medical decisions on your behalf? The most important of which would be who would make end-of-life decisions for you, but also who has access to medical information, right? Who can have access to your medical records in order to make a decision. And if you've been following the news lately with the debates on vaccinations, you'll hear a lot of talk about HIPAA. HIPAA is a federal law. California access to medical information is called SEMA. And these are the two sets of legislation that is covered within a healthcare directive. And your person that you nominate will then, in terms of these legislation, be able to say to a doctor, I'd like to see the medical record, or based on the medical record, I'd like this person to go in for a second opinion, right? So that's a healthcare directive. You should also have a comprehensive power of attorney for finances. And the power of attorney for finances, if you think of it this way, it's a transactional document. I am the principal. The person that I appoint is called an agent. My agent, I'm married, is my husband, right? I authorize the agent to transact in a certain set of circumstances. So I give them certain powers, certain authority to transact. You are allowed to buy and sell. You are allowed to talk to utility companies. You are allowed to talk to my credit card companies, right? The power of attorney for finances interrelates with your trust. So think of it this way. Remember I said to you, the bank account is in the name of the trust, right? The bank account is an asset that's owned by the trust. But the PG&E account is not a trust asset, right? It's not an asset at all. It's a debt. It's something that you owe PG&E, right? So PG&E sends you a statement and they've overcharged you. You lack capacity. Your agent under your power of attorney is going to phone PG&E and say, hey, you've overcharged me. PG&E will say, are you acting under a power of attorney? And they'll say, yes. And they'll send it off, right? Now you negotiate and you say, okay, I only owe only $100 is owed. The money to pay PG&E is in the trust. So the trust is going to issue the check, right, to pay the $100. But the discussion that you would have with PG&E would be under the umbrella or using your power of attorney for finances, right? It deals with those transactions, those relationships that are outside of the trust. The trust will pay the money, but not everything falls under the trust umbrella. And that, folks, brings me to 10:57 on the dot. I've given you a lot of information. If you have any questions, you are welcome to reach out.
Nerisha, that was really great and understandable. You made a very multifaceted topic simple to understand and follow. So thank you for that. And Vicki,
You're welcome.
Yeah, we have a few more minutes for questions if there's anything specific to you and your life. If not, feel free to contact and email. Oh, excellent talk from Carlotta. Thank you, Carlotta.
Yes, Carlotta. Yeah.
So feel free to email me afterwards. And if you want to get in touch with Nerisha, she does offer 30-minute free consultations too, if you need that as well. I'd be happy to connect you with Nerisha. Nerisha, thank you for your time. Appreciate it.
You're welcome. Welcome. I hope
you,
the sun
Nerisha.
comes on. You're welcome. Thank you very much.
Thank you.
Have a wonderful, bright, sunshiny day. And
Thanks, everyone. Good to see you.
take
Thank
care.
you.
Bye.
Bye.